All rise, Circuit Court's down in session. Honorable Judge Glenn Kelly presiding.
Okay, good morning. Please be seated. I was used to seeing the tables up here. I had to look for the parties. We're missing one juror. So we're still waiting on one juror, but I thought I would come out because there is one new motion I'm aware of filed by the defense. Is that correct, Mr. Rosenfeld? Well, what I've got on that is I've got exhibits on that were filed last night. I have not had a chance to review all of the exhibits because I just got them and I was doing my morning docket this morning.
I'm also asking for a modified instruction like that as the tapes come into evidence. That way the jury can be instructed that the content of the other parties is not being offered to the truth of the matter, so it's being offered to the effect on Ms. Dippolito.
Okay. I guess we'll get to that. we have to start. I guess, with the motion to suppress. But this particular recorded statement, when do you anticipate, or when would you be playing it?
For all recorded statements.
Oh, okay. This is for all recorded, but the one that's the subject of the motion to suppress, when would you be playing that?
This morning.
Okay, well, I was just given this package of documents to go through before I make a ruling.
There's nothing new. Are you referring to the state's documents or my documents?
Your documents.
There's nothing new.
Everything
in those documents is quoted in the motion. I just gave you a copy for the record.
Okay.
There's nothing additional aside from...
There's nothing new in here?
Nothing at all.
Okay.
Everything's quoted in the motion.
Okay. And so the state then on that motion is relying upon both the testimony offered at the motion to dismiss and also the additional portions of the recording that you want to replay for me. Is that correct? And defense is relying upon those matters which you've previously brought to my attention and filed for the record, correct?
Yes, and that would be the perpetuated testimony, the deposition, and the testimony from the motion to dismiss.
Okay, all of which I have.
Along with the confidential informant packet, your order.
The whole thing?
Correct.
Okay. All right. Why don't we go ahead, because we have a couple of moments, and apparently this is something that's going to come up quickly, and then I'll get defense comments on the special instruction in just a moment. Why don't you play for me what you wish to play for me? I assume you're going to renew your objection to foundation. Is that correct?
Yes, Your Honor. There's part of that tape's in
Arabic, we believe, I think.
I assume Arabic. I'm not even sure what language.
Not English.
Yeah, clearly improper foundation. We have no idea what he's saying. He could very well be saying that I'm being threatened to wear this wire. Your Honor has no context for what's being said in the tape.
Okay, again, I'm going to overrule the objection. I'll listen to those portions of the tape that the state wants to offer, and then I'll just hear a brief argument on this.
And just one question for clarification from the state. Does the state intend on introducing just the recording or the video also? Because Mr. Shihadi does indicate that he knows he's wearing a wire, but he said he did not know there were video cameras in his car.
Does the statute specifically apply to only oral interception?
No, I mean, it applies to all recordings. I'm just curious. I mean,
well, no, it's specific. It talks about, that's what I'm asking a legal question. Does it apply simply to oral, or does it include photographs? Or recording by... Mr. Williams, you got to tell me when you're ready for me to listen, because I'm having a comment. All right.
I'm just doing this to make you keep it up. I'm still trying to listen to you as well. I'm not necessarily sure about that, but even the video is the audio as well. The video has no value as the audio.
I think the answer to the question, Mr. Rosenfeld, is they're offering both. That's what I'm taking. Yeah, I mean, I think that was the direct question you asked. I think that's the direct answer, that they're offering both the recording and the filming.
I bring that up because Your Honor has the discretion. If Your Honor finds that he consented to being wired but did not consent to the videotape, Your Honor has discretion to just have them listen to the recording and not see the actual video.
Okay, and that's what the defense is asking me to do.
No, we're asking you to exclude both. But
No, in the
I'm saying
alternative, you're asking me.
Correct, is that
In the
described?
alternative, I understand what your primary request is. In the alternative, you're requesting that I do not allow the video. Okay. Are you ready to play whatever you want to play for me? All right.
What I want you to listen for, I believe he says, no, now they are following me back to the police station so they can unwire me. Then he says, I'm not going to be able to sleep knowing, he's cut off, and then he says, I'm not going to be able to sleep knowing that someone is going to get killed. I have to get it off my chest. That's the portion I'm going to play.
I'm sorry, now they're following me back to the police station so they can unwire me.
Judge, I have to get the microphone closer. This is not working.
Is another alternative just to bring that laptop up here and let you?
It's attached, Judge.
All right. Hang on, I can probably hear it.
Yeah, this will be much louder when I get the mic.
Hello? Hey, Elmer. Hey, from my dream.
I'll tell you when it starts.
Go ahead with
Yeah, go ahead. Give them, I got the evidence from the sorry for you beating another.
شوف البنت يعني ولا لا؟
Yeah. They admitted everything. I thought they were sorry. Now they're following me back to the police station so they can unwire me.
طيب خلص يكون الموضوع. That's good.
I can't. I'm not gonna be able to sleep knowing.
لكن سامع.
So I'm not gonna be able to sleep knowing that someone's gonna get killed. You know, I have to get it off my chest. You know.
لا خلص.
That's it, Judge.
Okay. So no additional evidence other than what we've already discussed, is that correct? Okay.
I guess I'm confused. Is the state trying to show that that's not hearsay, or that shows that he consented? What's there?
They're trying to show that it's relevant to the issue of consent. All right, well, let me just hear argument. I want to go ahead and try to move this forward if I can. Do you want to start, Mr. Williams, since you have the burden?
I'm just going to rest on all the evidence. You've already heard the witnesses. You saw the demeanor of Mr. Donati, all the way he exaggerated all the words they used. When I cross-examined him, we were able to uncover the truth that there was no coercion, there was no threats. And from his own words on August 1st, after he just did this, he says that he wanted to do it to get it off his chest, that he couldn't sleep that night. This was his idea to do this.
Okay. Mr. Rosenfeld.
Well, Judge, that's of little consequence. Whether or not he wanted to cooperate in the investigation doesn't determine whether or not he consented to being wired for purposes of the investigation or videotaped. I mean, Mr. Shihade has consistently...
Well, you're not contesting he consented. What you're saying, it wasn't voluntary consent.
Correct, Judge. I mean, he has consistently testified in both perpetuated testimonies, depositions, at the motion to dismiss, that he felt pressured into being wired into signing the confidential informant packet. That testimony has never changed. This litigation's been going on for, I mean, I believe his first deposition was over 5 years ago now, and he's never wavered or vacillated on how he feels about the signing of the confidential informant packet. And we can go through quote after quote here, Judge. Question, you talk to an officer who tells you you won't have anything to do with this, right? Yes. All you're doing is giving us information? Yes. And in regard to whether he actually read it, did he read it at the time? I read it very fast. I didn't pay attention to the little things. I didn't think this was something big. If it concerned me personally, I'd probably read it 20 times before I signed it. Did you read any part of this at all? Just roughly. Like what the officer, I think Moreno at the time, was showing me. Like, okay, said this page is for this page is for that. So I guess he skipped that page or a couple of pages and told me to sign, you know? I was really in a hurry. I was in a hurry. Like I said, I had a lot of things going on that year. Moving on, and this is most disturbing. I didn't read the last page till the end until he was referring to Miss Parker, showed it to me, you know. Question, all right. Well, forgetting about the last page, you read other things in there, didn't you? Not really. Moving on, Judge. Question, do you think they fooled you? Mr. Shihade's answer, signing the paper, yes. I'm wanting to sign a paper that I'd remain anonymous and confidential, and that's it. Question, is that what you thought you were signing? Answer, yes. Asked later on. Question, do you think they fooled you? Signing the paper, yes. Goes on about remaining anonymous. One moment, Your Honor. And when referring to the confidential informant packet, he said, and this is also very disturbing, it's like having a credit card and you read the fine print in the back. I really trusted the police officers. They said, you're not going to be involved. Moving on, Judge. If you look at one of the pages of the confidential informant packet, he didn't even write or sign his name on the top. Another officer wrote his name in on the top where he's supposed to fill in his name. He testified to that at deposition. It's not his handwriting. He didn't remember one of the pages in the confidential informant packet. So that just goes to the confidential informant packet itself. So, I mean, I'd argue that there's no question that not only was he pressured by Boynton Beach Police Department, he was confused about the packet, he was rushed into signing the packet, he didn't know what he was consenting to, he hadn't seen the last page, what deals with the wire and the recording, until 2 years later in the midst of litigation when Ms. Parker showed him that page. Now, even if Your Honor finds that he was not pressured, which I think Your Honor already ruled, frankly, in the motion to dismiss in that order, and I can quote Your Honor from that.
What I found was moral pressure.
One moment, Judge. I mean, Your Honor wrote, Mr. Shihade testified that he wanted to remain anonymous and did not want to get involved in the investigation or in the subsequent sting operation. He also said that he did not want anything to happen to the defendant. These facts alone are not particularly significant, and I understand that as it relates to the objective entrapment claim. You also said there is no doubt that the police applied pressure to Mr. Shihade to assist in the investigation that he started by reporting the defendant's desire to kill her husband. Now, Your Honor, as I guess Your Honor wrote in that order and implied, and Your Honor just said that moral pressure is what you found. Now, you're basing that on him backstepping during Mr. Williams' cross-examination. Now, when you weigh that compared to consistent testimony, and I mean consistent dating back 5 years as to feeling threats about being prosecuted, like I said, being confused about the packet, being rushed about the packet, not signing pages about the packet, which the state can't dispute, that's not moral pressure. That's being tricked and forced and rushed into signing a document. Now, assuming Your Honor finds that he was not pressured or that it was not involuntary, him signing the confidential informant packet, you also have to address whether he withdrew his consent. And he continuously tells them throughout that he does not want to be wired. I think there's 3 quotes in here I found, Judge. Give me one moment. But then they said that I had to wear a wire or that I would get in trouble. He told Boynton Beach Police Department, I don't know what you guys are doing, but I don't want to wear a wire. In regard to the recording, I said, I really don't want to do this. I said, I don't want to do this. They said, you have to do it. Then Officer Moreno contacted him countless times. Mr. Shihade said that Detective Moreno said, we need you, we need you, we need you, come in here, come in here. And he consistently told him to stop harassing him, to stop forcing him to come to the police station. Although he backtracked slightly at the motion to dismiss during cross-examination, and I'll read you the quote, were you threatened with criminal prosecution? Yes. If you don't cooperate, you can get prosecuted in a court of law. And I believe that the state more or less conceded to this claim, Judge, and I'm referring to the state's response to the writ of prohibition, where the state says, or they noted that officers informing Shihade that if something did in fact happen to petitioner's husband, he can be prosecuted was not a threat, it was a fact. Now, as Your Honor knows, the state prevailed, in that litigation, they prevailed with the writ. And I'd argue they're judicially stopped at this point from taking a different position. New Hampshire v. Maine, United States Supreme Court, the prevailing party cannot come in here and take a different position. And by doing so, frankly, Judge, they're making a mockery of this court. They're going to tell the 4th District Court of Appeal that he was pressured, that that's a fact, and then come in here and tell you that he was not pressured. That's not a genuine argument. That's taking two different positions. That's, without question, a due process violation in trying to litigate Ms. Dippolito. But we'd rest on that, Judge, that he was coerced and pressured. It was involuntary signing the confidential informant packet, and even if it wasn't, he necessarily withdrew that consent and showed that he was confused by continuously telling them that he did not want to wear a wire. Now, even if Your Honor finds that he consented to wearing a wire, you'll notice there's 2 excerpts in here where he indicates that he knew he was wearing a wire in the car, but he did not know or did not consent to video cameras being placed in the car. In which case, the state could play the recording, but they can't show the video to the jury.
Okay, anything further, Mr. Rosenfeld? Deputy Cascano, are our jurors here?
Yes.
Are they in the box? They're in the jury room?
Yes.
Nothing further, Judge.
Okay. I've had the opportunity to observe Mr. Shayada live at the motion to dismiss. And again, I do not believe the pressure rises to the level that would vitiate the consent. So I'm going to deny the motion to suppress as to both oral and also as to his videotaping. So the motion is denied at this time. The other motion that you filed, Mr. Rosenfeld, is a motion for mistrial. That motion can be heard at any time. I don't know that we need to keep these jurors waiting.
It'll take probably a minute to litigate if you want to get it over with.
Well, what I want to do is get the trial started. What I'm saying is I can grant a mistrial filed by the defense at any time during the course of the trial. It doesn't matter whether I've had them waiting a while. I'd like to go ahead and get the trial started, and then I'll hear your motion. So if there's nothing else we have to get to as a preliminary matter, what about the instruction? What's the defense's position on this instruction?
I got it about 5 minutes before Your Honor did.
Take a look at it. We've got a little bit of time before something's going to be played.
We're going to go right after openings. We're going right into the blind stuff.
A little heads up would have been nice on this, Judge.
It's
a standard instruction, is it not?
Judge, they didn't adopt it. It never went to.
It never went to. Okay.
Yeah, it didn't make it out of committee. I guess they didn't have time to review it. But this instruction, if you look at pages, I'll short circuit it for you on the 2 pages. If you go to McWaters, it starts on page 18. It's in the middle.
Are you requesting this instruction as to All recorded interviews,
Yes.
including the recorded statements between Ms. Dippolito and law enforcement?
I think you can, this is almost like an abundance of caution type.
Well, there's an instruction that the 4th DCA in case law has set forth for that they think is appropriate. It's not a standard instruction, but the 4th has said this is an instruction that we recommend trial courts give. This instruction, you're talking about giving this before the playing of which first recorded statement?
Judge, it's basically going to go in chronological order. So we're starting out with a few phone calls from Mr. Shahade to the defendant, then the meeting between the defendant and Mr. Shahade at the mobile gas station, then more phone calls 2 days later, then we'll skip over her and the hitman, and then finishing up some phone calls between her and Mr. Shahade.
All right, but specifically, the instruction, I mean, this instruction has not been completed. It says you're about to hear or watch, it could be one or the other, record an interview that contains assertions or opinions by.
And then we could put in there, either you could say individuals other than Ms. Dippolito, or we could specifically.
Well, why don't you do this? Why don't you prepare the specific instruction you're going to want me to read, show it to Mr. Rosenfeld, and then if someone, I'm assuming, I don't know who's doing the opening, but I'm assuming that someone could do that, you know, while we're doing the opening, and if I have to take a break to look at it. Whatever specifically you're asking me to read to these folks, I need you to prepare it for me and then show it to the other side so they can look at the specific language. So let's do that. I haven't even given these folks their preliminary instructions yet. So I need to do that. And then get into the openings. Who's doing the opening for defense?
Mr. Claypool.
Mr. Claypool. So, Mr. Claypool, you'll be doing the opening for Ms. Dippolito? Okay. And so perhaps Ms. Laurie and Mr. Rosenfeld can kind of share notes about this requested instruction, and we can get to the openings. Anything else we have to do before we bring these folks out? State, anything further? No. Defense, anything further? No. Okay. All right, let's go ahead and bring these folks out.
Jury entering.